Good morning, everyone, and welcome to everybody in the room and everybody who is joining us online on Zoom. My name is Nicole Fiddler, and I'm an attorney at Sanctuary for Families. Sanctuary is a New York-based nonprofit organization dedicated to serving survivors of domestic violence, sex trafficking, and other forms of gender-based violence. And we are delighted to sponsor today's panel. I direct the Pro Bono project at Sanctuary for Families, where we partner with over 1,000 private attorneys every year to provide free legal services to survivors. I also direct the Narquise Golan International Child Abduction Initiative, which is a relatively new project at Sanctuary. Our initiative focuses on improving outcomes for survivors who face Hague litigation. Our clients are typically protective primary caretaker mothers who flee domestic abuse to protect themselves and their children. The Narquise Golan Initiative is named after a Sanctuary client, a courageous young woman who fled severe domestic violence in Italy and came to New York, where she was born, with her young son in approximately 2018. This journey began a long and re-traumatizing Hague litigation in New York federal court that threatened to take away her son and their safety at any moment. Narquise fought for her son all the way to the US Supreme Court. Tragically, she passed away in 2022 before her case was ever fully resolved. At Sanctuary, we are honored to continue her work through the creation of the Narquise Golan Initiative. The initiative would not be possible without a generous grant from the Federal Office of Violence Against Women. I want to thank OVW for recognizing that this work is a critical piece in the fight against gender-based violence. I also want to thank our very generous host, Latham and Watkins. Latham supports Sanctuary's work in many ways, including by offering us this beautiful space and their incredibly talented event services team, who have been very responsive and have made this gathering possible. Latham is also providing boxed lunches for us after the panel ends. This room will remain open, and we hope that you'll grab a lunch, come back so that we can all connect and continue the discussions that the panel started. And if you can't stay, please do feel free to grab a lunch anyway to go. We will try to leave room for questions, although I'm sure we won't get to them all. If you're online, please put the questions in the Q&A box, and we'll be monitoring that. In the room, there's index cards and Post-its on your table. You can put the questions on those and flag down. We have Natalie in the back. Natalie, can you wave? And there will be some others sort of standing around in the room who you can flag down to give your index card to. Or you can just pass them up front to my colleague Leslie, and I will be looking at the index cards and monitoring the questions. I think also you may have noticed that this is being recorded. So we ask you to please make sure your cell phones are off. And if you have to leave to use the restroom, please just leave through the sides and not through the middle, which is where the camera is. And be assured also, we're not recording audience members. So the recording is just the panel. So now I would like to introduce our wonderful panelists. They all have very impressive bios that you can read about in your program or on our event page online. But in the interest of time, I'm just going to briefly introduce each of them. So we are thrilled to be joined on the big screen by Reem Al-Salem, UN Special Rapporteur on Violence Against Women and Girls, who has been instrumental in raising awareness of the harms that Hague mothers and survivors face. We are incredibly grateful for her efforts. We also welcome on the screen Dr. Adrienne Barnett, professor and scholar at the Brunel University of London. I had the privilege of hearing Dr. Barnett present at the Hague Forum on Domestic Violence in South Africa this past summer, and I can't wait to hear her brilliance again today. Here in the room, we have Janaina Albuquerque, who was another phenomenal presenter at the South Africa Forum this summer. She's a dual qualified lawyer who practices between Brazil and Portugal and specializes in complex cross-border family matters. We also have Maria Vallejo, a dual qualified lawyer practicing in the US and Mexico. She directs the binational project of family violence at Texas Rio Grande Legal Aid. and Merle Weiner, who's a professor and scholar at the University of Oregon School of Law, will be moderating the panel. Maria and Merle are both on the Narcís Golan Advisory Council, and it's been my privilege to collaborate with them over the past couple years on Hague issues and cases. I couldn't ask for a more compassionate and knowledgeable panel today. And with that, I'm going to turn it over to Merle to start.
Thank you, Nicole. Well, thank you to everyone in the room and to everyone online for your interest in the subject of today's panel, which is strengthening the Hague Abduction Convention for domestic violence survivors. And we are very lucky to have Nicole and Leslie both put together this panel for us and arranged this wonderful space at Latham and Watkins. So thank you for doing that. So I have been asked to facilitate, and what I thought I would do is ask our panel of experts a series of questions really to elicit why the Hague Abduction Convention has to be strengthened for survivors of domestic violence, what's being done to strengthen it, what more might be done to strengthen it, and as part of this conversation, why we're talking about this at CSW69. Then we'll have time for questions, and you heard, if you're in the room, please write your questions down on index cards, and if you're online, in the Q&A. So I want to jump right into it. And the question is, what is the Hague Convention, the Hague Abduction Convention, for those of you who may not know about it, and why does it need to be strengthened for survivors of domestic violence? And I thought, Adrian, you might start us off by telling us what is the Hague Abduction Convention, how it works, and maybe in a very general way, why it needs to be strengthened for survivors of domestic violence.
Certainly, Will, thank you. So the Hague Abduction Convention is an international treaty which is currently ratified by 103 states, and its aim is to provide a quick mechanism to return a child to their country of origin. And in that way, it's called a remedy of hot pursuit. Now, the stereotypical picture of a child abduction and that which was envisaged by the drafters of the convention was of the non-custodial parent kidnapping the child from the custodial parent, usually the mother, and disappearing with the child. What we know now is that it is most usually primary caregiver mothers who get caught up in the convention, who are trying to return back home to their country of origin to escape domestic violence. In fact, what we know from latest statistics is that about 75% of so-called abductors are mothers, and 94% of them are children's primary carers. A large proportion of whom, it's thought at least 75%, are escaping domestic violence. The convention provides a limited defense to a parent who wants to resist the prompt return, bearing in mind there is no defense of domestic violence. And it's called the grave risk of harm defense, which can be found in Article 13(1)(b). And it's very tough to succeed in this defense. The courts of most states apply it very strictly. And there's also a huge variation in how contracting states apply it. There was a report by the European Union in 2015, which collected data from 16 countries, 9 of which made no mention at all of domestic violence. It was simply not even thought about. The vast majority of those states who reported to the EU said that they applied a restrictive interpretation of Article 13(1)(b) and indicated that it was rarely successfully pleaded. Now, the courts also tend to rely on what are called protective measures. Now, the problem is this approach is based on a physical incident model of domestic violence. And this kind of approach can only be sustained by continuing to minimize the risks of domestic violence and placing the onus on the victim to keep herself and the children safe, rather than holding perpetrators accountable. There's a very severe focus there's a focus on severe physical violence as constituting domestic violence, with a lack of recognition of coercive control, which we know is the most prevalent and dangerous form of domestic violence, and also insignificant recognition of the harmful effects of domestic violence on children. So that gives an overview of what the convention is and what the problems are.
Thank you. That is very helpful to kind of orient us. I guess I want to back up one step and explore why survivors of domestic violence may need to flee transnationally. That is, I think many people may wonder, why don't they just get support and some sort of resolution in the place where they are? So, would anyone like to address that particular question?
Okay. Well, that's one of the toughest and most important questions to answer, because the thing is, for migrant women specifically, the challenges are sometimes unsurmountable. It is already hard for any woman to get help in case they need protection against domestic violence. But migrant women, they face additional challenges. They are subject to multiple kinds of vulnerabilities. So things that may seem as simple as filing for a police report may be impossible for these women if they cannot speak the language. And that kind of turns into a snowball effect. So they are not able to get the protection or to access the protection. And they are also subject to multiple kinds of discrimination. There is a racial angle to this. There is a cultural angle to this, and that all has to be taken into consideration. So they flee because of many reasons. But first of all, if they can get help, sometimes they cannot get help. But they also feel like they need also their support system. They need their network. They need to be understood. They need to protect their children. They feel like they are very discouraged in the system. They don't trust the system anymore. And they might also not know about the convention. For us who work in the field and we know about international family law, we know about the Hague Conference, we are all very familiar with the convention, but that is not really the case. And it's not everyone that understands this particularities and complexities of private international law. So they might be under the assumption that, okay, for example, I am Brazilian, my child is Brazilian, Brazil can help me. And that might not always be the situation. And they come back, they expect to get protection. They might get some sort of provisional protection for some time. And then they are faced with a Hague proceeding, and there is a big feeling of distrust. There's a big feeling that they went there to their home countries to be sheltered, and they cannot do that anymore. Would anyone like to comment?
Yeah, I would just like to add that sometimes they just want to put some distance between the abuser and themselves. So we know that domestic violence is a private matter. We know that some of them will not be able to share their circumstances with friends or families because of the same reasons. They might not trust the police, or they might decide not to make reports to law enforcement, or even seek medical attention. So they could even ask for counsel and try to seek the assistance from an attorney who tells them that as long as there are no custody orders, they can do whatever they want. And like Janaína said, if they believe that if the child is Brazilian, they can go to Brazil because that's their country. But then they quickly learn that a Hague Convention petition or application can force them back to the country of their abuser.
So all of that actually echoes, I think, what some of the academic research shows. There was a study by Jeff Edelson and Taryn Lindhorst that looked at 22 mothers who had Hague petitions in the United States. And in talking to those mothers, they found that most of them had reported multiple attempts to seek help in the place where they were unsuccessfully, both formal and informal help. And so they often were coming to get support. 40% of those mothers reported that they weren't even in the other country voluntarily, that they were coerced to go there by their perpetrator. And so it makes perfect sense that they would want to then come home or go to someplace where they would have support, especially if they couldn't get any sort of help in the place where they were because they were migrants. Okay. Well, so we have a sense, I think, of why women may flee with their children. And so let's think a little bit more about the Article 13(1)(b) grave risk defense that Adrian mentioned. I guess I want to know why it doesn't work, because if you think about it, these are court proceedings, and we all, I think, know these days that domestic violence and exposure to it can be harmful for children. We know about separation violence. We know about the coexistence of domestic violence and child abuse. All of these things seem to suggest that this defense would work, but yet what we know is it often doesn't. So let's unpack why it doesn't. Why doesn't this defense work for survivors?
Well, we are told that the defense should be applied restrictively. So, for example, in the US, we have this made up standard proof that is nowhere in the convention and nowhere in the explanatory report, clear and convincing evidence. And clear and convincing evidence is the highest burden of proof for civil cases. So for domestic violence victims that could have probably left their country in a rush, it's very hard to gather evidence before you have to leave. And then if we take into consideration that these procedures are expedited, it's also very hard to gather that evidence during the proceedings themselves. So a domestic violence victim might not have the resources or the finances or even possibly the know-how to retain an expert to talk about the effects of domestic violence in children or get a psychological evaluation. And sadly, because of such a high standard of proof, sometimes this is required to be successful in cases like this.
Okay, thank you.
Yeah, so essentially, Article 13(1)(b) is quite hard to work with because with any international convention, you're trying to get a compromise. And that's the point when you are interpreting the Hague Convention. Article 13(1)(b), it was drafted with open concepts such as grave risk, controllable situation, which means that any country or any judge, any court can apply its interpretation, right? So it would mean that we can have multiple interpretations, but that's not how it works with an international convention. There is an expectation of uniform interpretation. So countries, they restrict interpretation in order to achieve forcibility. And that means that explains why Article 13(1)(b) is supposed to be interpreted restrictively. And we do have some sort of guidance from the Guide to Good Practice that was published in 2020, but on the topic of domestic violence, it is on the fence. So it doesn't give a straightaway answer to how it is supposed to be included and considered. I think also one thing that needs to be taken into consideration as regards grave risk and why it doesn't work, apart from not being able to gather the evidence, apart from the legal restrictions, the legal borders of article itself, the burden of proof lays also on the taking parents. But it also, in my perspective, it also has to deal with the fact that countries do not understand that domestic violence or intimate partner violence affects the child. There is this fragmentation between domestic violence and custody. And it's not very uncommon for me to hear that it's not because he is a bad husband that he's going to be a bad father. and one thing does not have to deal with the other. So I practice in 2 jurisdictions. I practice in Portugal, I practice in Brazil, and it's very different approaches to that. Of course, Brazil is not perfect, but there's more integration in that system. So we have domestic violence courts that they have jurisdiction also over some custody matters and some matrimonial matters as well. And in Portugal, it's all separated. And there's a clear difference when I look at cases and how they're handled, because when we fragment those two things, we invisibilize the violence and the abuse in between. And that also reflects upon the Hague Convention, because it's also not uncommon for me to read Hague decisions in which they say, okay, there might be evidence of violence against the mother, but I don't see how this is affecting the child.
At this point, it may be helpful to just share what the defense actually says so everyone can see why this is a problem. So the Article 13b defense, which is the one most survivors of domestic violence invoke, says that the judge is not bound to order the return of the child, quote, if there is a grave risk that his or her return would expose the child to physical or psychological harm, or otherwise place the child in an intolerable situation. So you can see how some judges might say, well, there's abuse against the mother, but I don't see how this is going to affect the child. Are there other barriers? Adrienne, do you want to add something?
Yes, one of the biggest barriers is the use of this protective measures approach. In many cases, in many of the reported judgments, for example, in England and Wales, the court may be persuaded that the child may be at risk, but inevitably, they usually consider that some form of protective measures, which are usually in the form of an undertaking given by the parent seeking the return, will mitigate that risk. And that's one of the biggest problems one's up against, is that you've got this very strict interpretation of what constitutes a grave risk or intolerable situation, but this assumption that this can be mitigated.
Okay, and we'll come back to that, I think, in a moment when we talk about the Guide to Good Practice. I wanted to just mention a couple other things that I've seen in the cases that have been really problematic. You know, judges will sometimes say that the violence isn't severe and frequent. Therefore, it's not serious domestic violence, with no understanding about coercive control or how domestic violence actually work. At least in the United States, our judges who hear these cases are generally federal court judges who don't have necessarily any education on domestic violence at all. Sometimes they will disregard the importance of a child remaining with a protective parent. And although, you know, say the parent can't return with the child, and so the child will be separated from their primary caregiver, and that's so important, and that might be a grave risk of psychological harm or an intolerable situation, the court will say something like, well, the mother brought this on herself. She's an abductor. She caused this bad situation. So if the child, you know, she can't use that as part of the defense without understanding kind of the entire dynamics and how important that relationship was. There's other problems too. I think the courts tend to disregard the intolerable situation language. And oftentimes, I think we'll hear in a moment how horrible things are for children and the taking parent when the child is returned, and how that should be considered an intolerable situation. But courts tend to not really give that part of the defense very much emphasis. Anything else? Is there anything else that we should talk about? How about inequality of arms? What about that? Isn't that a problem too with the defense? I don't know if anyone would like to explain what inequality of arms is.
Well, if we if we go to the letter of the convention, we know that it was created out of this desire to protect children of the harmful effects of a wrongful abduction. And a wrongful abduction is considered a relocation that is against the custody rights of the other parent, a breach of the custody rights of other parents. So the consensus seems to be that removal will almost always be wrongful when it's in breach of these rights. And there's some practitioners that even go as far to say that this removal, it's a form of domestic violence, and it could be even a worse form of domestic violence than actual adult domestic violence or exposure of domestic violence in children. But we have had years and years and years of social science research, and we know that that's not true, that not all removals are harmful if we are seeking to protect the child. But this is the way the convention is drafted. There's a presumption that the return of the child is the best for the child. So respondents, in this case, mothers fleeing violence, have to swim upstream in these cases. And to this, we add the fact that most of them struggle finding legal representation. For petitioners, we know that, for example, the recommendation they try to encourage central authorities to find an attorney pro bono legal aid for petitioners in any way possible for petitioners. But there's not such guarantee for respondents. So in many cases, they have to represent themselves on their own. And as we explained before, that's very hard because the defense is so hard to prove. You have different standards of evidence. So the play field is not even, right? So to give you an example of a terrible case, I became aware of a case of a mother that was briefly incarcerated in Mexico. Years before, she had come to the United States after obtaining sole custody of her child. They were living in the United States, and suddenly she was served with a petition for return under the Hague. After service, the hearing was set 1 week later. She tried to ask for more time to find an attorney, and the judge didn't give her more time. This was in state court. So she had to represent herself. She didn't speak English, so she had to do it with an interpreter. She didn't have anyone else to support her because her husband was excluded from the courtroom because he might have been called as a witness. So she was all alone, trying to present evidence of the abuse that she endured during the time that she lived with the father of the child. And she wasn't able to do that. And she also wasn't able to show that the custody order that the father was presenting had been vacated. He was claiming that he had joint custody, so the child should have been returned. And since she was not able to prove otherwise, the child was ordered returned to Mexico. The hearing lasted 1 day, the merits hearing, and she had to return with the child. And of course, she didn't want to just give it to the abuser. So she returned the child to Mexico, but she was immediately arrested. So by the time that she was able to clear up the situation with the custody order that showed that she had sole custody of the child, father had already absconded from the jurisdiction, and they couldn't find the child. So if you don't have legal representation, competent legal representation, it's very, very hard to succeed in these cases.
Also, in certain countries, that's the case for both Brazil and Portugal. The left behind parents will have some sort of representation, not exactly representation for the left behind parents, but the proceedings, the Hague proceedings, will be initiated without the need for the left behind parent to hire a private lawyer in the country where the child is located. So that means that I will talk about the Brazilian scenario in this example. But so the Attorney General's office initiates proceeding not in the name of the left behind parent, but in the name of the state to request the return of the child, but never to request the child to stay. And then the taking parent, who is in Brazil, has to find private representation or can resort to a public defender, but there is a limit to the wage and also a limit to the earnings of the whole family, and it's quite low. So that means that taking parents, they have to find representation. But the thing is, in the Brazilian legal system, you are not allowed to defend yourself unless you are a qualified lawyer. And that means that you have to hire a family lawyer who might never heard of the Hague Convention in the first place. So your defense goes down the drain. And then there is a very strong inequality of arms in this situation, because these mothers are often very ill represented, and they do not even have a chance to fight back, because the Hague Convention, I mean, it is quite famous. There's a lot of cases, but it is still a niche. And it's not that many cases that justify specific attention. And circling back to what Murray was saying as well, in Brazil, it's also heard by federal courts. And that means that federal judges hear the cases. They are not necessarily well acquainted with family law and domestic violence, but this may be one case in their whole career. They are not going to take the time to study the subject in depth in order to give a sort of decision. So that might as well lead to a very prejudicial decision to the victims.
Did you want to add anything, Adrian or Reem, on the inequality of arms point?
Yeah, yes. In England and Wales, the applicant parent is entitled to non-means tested, non-merits tested legal aid. And there tends to be, this is a very specialist area, so there are very senior KCs who represent parents in these cases. So they will get the best representation automatically with legal aid, whereas the respondent parent is entitled to merits and means tested legal aid. And very often, because they are the so-called abducting parent, it's hard to meet the merits test. And so they can find themselves with no representation or very limited representation against the applicant parent who is, has the best representation, and it simply does not provide equality of arms at all. Some are lucky and they can find pro bono representation, but that's not the way to run a system. And these proceedings in England and Wales are so quick as well. They call them summary proceedings, which means that generally they don't hear evidence. They try and get them done, which again is problematic.
Yes,
so what
absolutely.
we've heard, oh, go ahead. Yes, please.
Yes, I completely agree with Adrienne, and we're going to come to this issue about the gendered aspects of returns under the Hague Abduction Convention. But just to say that specific groups of women or mothers are even more vulnerable to inequality of arms because they don't have access to good legal representation. And perhaps this is the right moment to say that actually having access to legal representation, legal aid, is actually a right in international law. The CEDAW Convention says states must ensure free or affordable legal aid for women experiencing violence. And also the CRC in its Articles 19 and 39 requires states to protect children from forms of violence, which also includes ensuring access to legal aid.
Yes, I mean, it's hard for any survivor to represent themselves, but if you don't speak the language, you're isolated, you're not in your home country, those problems are so compounded.
So just to make an obvious point, I mean, here is this law related to international child abduction that seems like it would be a very useful tool for a batterer who wanted to continue to perpetrate the abuse after someone fled, because that person's going to have legal representation. The law is stacked against the survivor. It involves her child, all of the things that make this, I think, consistent with litigation abuse generally that batterers perpetrate against victims. And then when you think about how people are reversing, or the batterer is reversing who the wrongdoer is, the mother's the abductor, right? This is kind of classic Darvo, right? This is a term coined by Jennifer Fried, but here we have somebody who is denying the abuse usually, and reversing victim and offender, and using the law to further the abuse, I think. Well, just to make the obvious point, I guess, again, Adrian, maybe you could remind us why people would create this instrument for batterers to further abuse domestic violence victims.
Yes, sorry, go on.
Yeah, no, go ahead. I was just bringing us back to your first point, I guess, with what the Hague was created for and how this is an unintended consequence, I think.
Right. Yes. So the Hague was created, as I mentioned briefly at the beginning, to enable children to be returned quickly if the non-custodial parent, who was usually the father, snatched the child or wouldn't return the child, say, after an access visit, and then disappeared abroad with the child. And to that extent, the convention has been successful, and there are cases that come before the courts of that description. But it's because that is not the general pattern of most of the cases that do come before the courts, that it has become a tool that can be used by abusers. Very often, the parent who is seeking the child's return may not have ever lived with the child, may not have that much contact with the child. And what they're really trying to do, it's not a real custody dispute about who the child should live with. What they're trying to do is get the victim and children back into their environment, because we know that one of the tactics of abusers, of post-separation abuse, is that they want to continue exercising control over their victim. We know that post-separation abuse is a huge problem, and the Hague Convention can allow itself to become a tool of that sort of abuse.
I think adding up to what Adrian has brilliantly explained is that if we take into consideration the context in which the convention was drafted, it was the end of the 70s, and we didn't have extensive framework in international law. CEDAW had just been adopted, and there was no Convention on the Rights of the Child and many other human rights instruments at that point that protected women and protected children. And of course, women can talk a lot more about this and go more in depth about that. But I think we forget that they didn't have at the time the tools they needed to take that into consideration. Not even domestic law for domestic violence, and not extensive international law.
Before we get into the human rights, I just want to kind of close the circle and learn a little bit about what happens to children and survivors when the court denies the defense and sends the child back. So maybe the panelists can talk a little bit about what your experience is, assuming, of course, mothers can go back. What is your experience with what happens after a Hague abduction proceeding?
So that's a very good question, if they can go back, because the convention only deals with the civil aspect of child abduction and not criminal, but it also doesn't stop countries from putting in place criminal sanctions. And that means that most European countries and the US, Canada, they all have some sort of a provision in their criminal legislation regarding child abduction. And that for a migrant person can entail a prosecution and possibly imprisonment. It can lead to the cancellation of permits, the cancellation of visas. It can also mean that you are not allowed to enter that territory anymore. And especially if you're talking about, for instance, the European Union or the Schengen area, if you are And if you're not able to enter one of the Schengen countries, you are not allowed to enter into the whole Schengen territory. So that really limits your movement. They can also entail the automatic, sometimes in some legislations, the automatic inversion of custody. So the taking parent will lose custody as one of the sanctions. It could also lead to fines, which reach astronomical levels. I know of mothers who are facing now up to hundreds of thousands of dollars and euros in fines to the state and the abuser as well. So if they are able to come back, and that's a very big question, once they come back, how is it going to plan out? Is she going to have, depending on the separation, they might not able to have the family reunification right to stay in that country. Are they going to have housing? Are they going to have some sort of income? How are they going to provide? Are they going to have access rights to the children? Are they going to have legal aid to fight for custody? I'm the legal coordinator for Hevibra, which is an NGO such a sanctuary for families that helps these women. And in our numbers, it can take at the minimum 2 years for the mothers to be able to see their children without supervision again after the children have come back. And we have cases that it has been 10 years and the mothers still do not have access to the children anymore.
Would anyone else like to add? Yeah.
Yes. So I've come across cases or women that have, particularly that are citizens of EU countries and that have fled to other European countries, and they have tried to seek asylum, arguing that they are in need of international protection. Now here they are usually confronted by two main problems. One is that there is no really custom to look at such cases under, let's say, the 51 Convention, the 67 Protocol relating to refugees, or any of the other regional, let's say, treaties covering international protection or refugee status. And then when it comes to Europeans, of course, you have the additional barrier, which is that you have the safe country of origin principle, which is that under EU law, the Asylum Procedures Directive, EU member states are generally presumed to be safe countries of origin. So meaning that their citizens are unlikely to face persecution. So that then means that they are really in a very serious limbo situation, even in the country where they sought refuge or are trying to find protection, and are under constant risk of being removed also or returned.
How about safety? Do we know anything about whether or not when women return, they're re-abused by the perpetrator?
Shall I come in here?
Sure.
Yeah. So the difficulty, of course, for mother, one of the difficulties is, that they will be returning back, say, to the courts of the child's habitual residence, which start off with the view of the mother as an abductor. But going on to the wider problems, we know from research how it's, perpetrators show very little regard for, so-called protective measures, restraining orders, injunctions, undertakings, that sort of thing. We know that abusers are highly prone to recidivism. They're likely to ignore or defy court orders. There's a high level of breaches of injunctive orders. And in many jurisdictions, including a recent report from the BBC showed, low levels of enforcement. So this is the reality of the situation. Relying on protective measures doesn't to be enforced in this country to which the mother and children have been returned, doesn't account for the complexity, the dangerousness, the unpredictability of domestic violence, the propensity for abusers to continue the violence. Also, the sort of inability of courts that are ordering returns to properly assess the efficacy of measures in another country. And the high probability that they'll be useless because the abuser will disregard them and they won't be enforced. In fact, there was a recent online survey that was conducted by Hague Mothers and Global Arc of mothers from a number of countries who reported that protective measures, even those where mirror orders had been obtained, weren't enforced or were very difficult to enforce. And then, of course, there's, the problems that you've spoken about already of the dire living circumstances that returning families can have with lack of money, having to rely on the abuser. Very often the abuser may give various undertakings to the court, which is something that happens in England and Wales, where they will undertake to provide accommodation for the mother and children, provide them with money. And then when they return, none of this is forthcoming. In some cases, children may be compelled to live with the abuser or in some form of shared care arrangement. And then, of course, there's, contact. Even if the children remain with the mother, they may be expected to have contact or access with the father, which can be highly dangerous because what we know is that child contact is a key site for the perpetration of continued or even more serious abuse and, at worst, homicide of mothers and children. And these problems of post-separation abuse, of course, are exacerbated for women and children under the convention, returning under the convention, because they've got all these additional vulnerabilities through language difficulties, lack of a support network, isolation, poverty, and so on. So it's a perfect storm for continued abuse, really.
So I was going to ask you maybe, Adrian, to share the story of Cassandra as an illustration, I think, of just what you've been saying.
Yes, this is a really tragic case of Cassandra Hasanovic. She was an Australian mother of 2 boys living in England. She was a victim of very serious domestic violence by her former husband, then her husband. He'd been removed from the home by the police on a number of occasions, charged with serious criminal charges. The latest that was in 2007, and that enabled Cassandra to escape back to Australia with the children. However, an Australian judge made a return order to England for the children under the Hague Convention, saying that the authorities in the UK should and would be able to protect her. This judge got the father to agree in writing to certain conditions, for example, not to come within 250 meters of Cassandra or the children, not to contact her, to vacate the home, etc. So Cassandra and the children then returned to England. The father completely ignored this agreement. Cassandra obtained a non-molestation order, which is a form of restraining order. She had to continuously call the police. The police gave her a panic alarm. They responded to several violent confrontations. But Cassandra so feared for her life that she decided to move to a refuge. She asked the police for help, but they wouldn't give her a police escort. And when Cassandra and her mother and the 2 children got in the car to leave for the refuge, the father appeared. He dragged her out of the car and he stabbed her to death in front of the children. He was subsequently jailed for murder. But of course, that's too late for Cassandra and her children.
Does anyone else have a story about how the convention plays out for particular survivors?
Well, before I tell a story, I think I would like to add a couple points. first of all, that the convention itself does not provide for any obligation of the states to comply with protective measures. So it's really up to discretion of the judges. And even if they are willing to grant protective measures, there's a question of jurisdiction, because can a judge, for example, if you have a case between Brazil and the United States, can a judge in Brazil ask the immigration authorities in the United States to not cancel that mother's green card? I don't think so. And also the fact that with protective measures and the whole perimeter of what entails a safe country and if they're going to be effective, I would also like to bring a reflection that it's really hard when you're arguing a case in Brazil to say that the United States is not a safe place for a mother to return to. And the global South, global North dynamics is really, really emphatic in the situations. At the same time, it's also very hard when we are arguing a case. For instance, if a Brazilian child has been abducted to an European country or to the United States or a global North country, I think in my experience, judges are more willing, for example, to say, okay, just to give you the reflection, to ask yourselves that question, wouldn't you think that perhaps a global North judge would say, perhaps, yeah, Brazil is not the safest country for the child to go back to? And I see that a lot in Portugal cases. So that double standard it's really present in my perspective. One small story that I would like to share perhaps is that a failure of protective measures, that there was a mother and she was from Brazil, but she was living in a European country, and she was under domestic violence, and she was one of the lucky ones who got a restraining order. She actually got a restraining order. She initiated custody proceedings, and she made an agreement with the father that he would be willing to let her go to Brazil if she withdrew the criminal charges. So that's what she did. She withdrew the criminal charges and she went to Brazil. But at the same time, a few weeks after she arrived, she was surprised with the Hague service of order. And she was served. She had to face the Hague proceedings. And they decided, even though she had extensive evidence of the abuse, that she would have to go back. And the enforcement stage was appalling, because they put in place very, very hostile measures to ensure the return would happen. So all of her family members and her phone numbers were bugged. Her bank accounts and her family members' accounts were frozen. They also entered her family members' houses. There are other cases, not this particular one, but we have gotten notice of even judges mandatory ankle bracelets for the mothers to ensure they would not flee the territory. So these are all very hostile measures to ensure that the enforcement is going to happen. And they also were negotiating with the European authorities to make sure that nothing would happen to her when she got back. So she was allowed to travel with the child, but it just so happened that when the plane landed, and there was a notice from the pilot saying nobody's supposed to get up yet. And then child services and the police got into the plane. They took the child and she went down the plane straight to the police car, and she was arrested immediately. And when there were ensuring between authorities that nothing would happen to her when she got back. And that's the mother that I mentioned, that it has been 10 years and she is still not able to see her daughter without supervision. So this is an example.
So we've, I think, explored a little bit what the Hague Convention is, why it's problematic for domestic violence survivors. And I want to kind of pivot a little bit now and think about why we planned this panel for CSW69. And so, Reem, could you maybe talk to us about the gender dynamic that you see in these cases, I guess, both with the domestic violence and the who's the primary caregiver?
Sure. There's a very strong relationship, actually a very strong gender dynamic. We know that most of the domestic violence victims are women. And these women, who are also mothers, are the majority of those that are then subjected to the Hague Convention. This is something I referred to very briefly in the report I presented to the Human Rights Council in June 2023 on child custody and violence against women. In that report, I have referred to the fact that around 3/4 of all cases filed under the Hague Convention are against mothers. So there's one very clear gender angle. And of course, the reports from states to the Permanent Bureau of the Hague Conference on Private International Law, and also the information that has been received from affected parents, have shown also that many of these mothers have been subjected to domestic abuse or domestic violence, and that in a number of cases also children may have been experiencing domestic violence or also sexual violence. Now, we know that harmful gender norms, which are the social expectations that define what is considered appropriate behavior for individuals based on their sex, and that devaluate women and girls, are the same norms that promote that this idea that violence is often justified or necessary, including to correct children and women's perceived misbehavior. And the research has revealed that men who support gender inequality are also more likely to use violence against children and violence against women. And that men who think intimate partner violence against partners is justified are also more likely to use it to violently discipline their children. I want to just, however, emphasize that the gender dynamics, this strong gender dynamic, doesn't only affect, let's say, the victims, women and children, or the perpetrators, but also the judges that deal with the Hague Convention. Because as was already mentioned, if judges examining the application of the Hague Convention have a gender bias, then they will not identify the fact that domestic violence against mothers or children have occurred. They will not recognize the dynamics, which, as was mentioned, can also include non-physical forms of violence, so psychological violence, including coercive control. And therefore, they may also then miss this relationship between allegations of domestic abuse and then also these very concerning allegations of parental alienation and then therefore this being part of this DARVO approach by the perpetrator, as I mentioned. And the other thing is that you may also recall that in this same report I presented to the Human Rights Council, I had also referred to this very concerning tendency of family courts across the globe to dismiss the history of domestic violence and abuse, particularly in custody cases, especially where mothers or children have brought forward credible allegations regarding domestic abuse. So they tend to dismiss them. They tend to think that women or mothers are deliberately falsifying evidence and are trying to also manipulate their children and to separate them from their fathers. So therefore, in that report, I had also said very clearly that judges need to examine the case based on facts and ensure appropriate risk assessments. And while there is an overall gender element, there is, as we said, no doubt that including within the group of women, there are certain groups of women that may be even more vulnerable. So we see basically gender-based discrimination intersecting with other forms of discrimination. So women that are migrants, women that have a precarious legal status, women that are poor or don't have access to resources, women that come from racial minorities, indigenous women, etc., they will face even more negative consequences because this gender bias or this the gender-based factors will intersect with other parts of their identities or profile.
Thank you. I think we need to now turn also and start thinking about solutions. And I want to come back to the potential human rights systems and how that might be a solution. But I think before we do that, we just have to ask whether or not the Hague Conference has done anything to address this problem, because there have been a lot of people who've been talking about this problem. And the Hague Conference is the one who created the Hague Convention on the civil aspects of international child abduction. And so I think we'll just take a minute or two to talk about what they have been doing to address this particular issue.
Well, the Hague Conference has many international family law conventions, being the 1980 Hague Convention one of them. And in order to change the convention, it is very hard because everything in the Hague Conference is approved on consensus, which means that if one of the countries disagrees, it's not going to go forward. So taking into account that this is a very polarized subject, it's very unlikely that any change to the convention itself is likely to happen. But that being said, there are other ways to make sure that the convention does not become obsolete, in the sense that it continues to be applicable for contemporary issues. And one of those initiatives is, for instance, the Guide to Good Practice. That's what they did in the last the second to last, the one before, special commission meeting. And just to, for who doesn't know the operation of the Hague Conference, there are periodic meetings that happen every 5 to 7 years in order for states parties to discuss the current issues with the instruments. And there was a special convention in 2023, and the one before that, if I'm not mistaken, was 2017. So in 2017, they brought up the issue with the application of Article 13(1)(b), and so they asked the Council on General Affairs and Policy, which is kind of like the General Assembly for the Hague Conference, to establish a mandate to draft a Guide to Good Practice. So they did, and the guide was published in 2020. As I said before, it's very on the fence with the whole domestic violence situation, and there's many criticism on top of how it's drafted and how it approaches the issues of domestic violence. And then there was another special commission meeting in 2023, and that brought the subject of domestic violence to the forefront. So there was a lot of engagement from civil society organizations, and they tried to talk to their governments and to bring attention to the issues pertaining DV. And at that special commission, it was recommended that another meeting was held, in an open meeting, which means not just government officials, with other stakeholders, to better discuss the issues of domestic violence. So CGAP last year, March of last year, established that a forum would be held to discuss Article 13(1)(b) and domestic violence. And that was a meeting we had in South Africa last June. And that was a historical meeting in many ways. I think the biggest outcome of that meeting is that we can no longer ignore that domestic violence is a pressing and perhaps the most concerning issue regarding the application of the Hague Convention. So it is out there. How are we going to deal with that? We don't know. There is another forum that is going to be held in October this year in Brazil. And they are still organizing it. There's no there's no clear goals so far, but it is very difficult when we try to even establish a step-by-step plan on what we're going to do, how we're going to address it, because we are still covering our bases in the first place. We are still trying to understand what are the problems, what are the possibilities, and how far we are willing to go. But does Adrian, perhaps you want to chip in as well? Adrian is also part of. Yeah. Oh, I think your microphone is off, Adrian. Yeah.
Yes, the South Africa Forum was a great start, and as you said, Janana, it's great to get that these issues were discussed, talked about. It's out there. It can't be put back in the box. But what we hope is that moving forward in Brazil, we'll be looking at solutions and how these can be implemented. So that's, I think, is what we're hoping to be moving moving forward too. And it seems, I think there's a general will amongst the participants who'll be planning for and attending the Brazil Forum, that it will be a catalyst for making changes.
I guess I just want to add that to date, I think there have been two camps. One camp, which is evidenced by the Guide to Good Practice, and I think the Hague Permanent Bureau, is this faith in protective measures that you've heard. That is, the solution that they see to this problem is make sure that there are protective measures when you send the child back, and then mom, will go back and she'll be protected. The problem with that is, of course, that's not in the convention. That takes away the defense that would otherwise exist for the mother. And there are these vast differences between an enforceable protective measure and whether or not it will actually be enforced and whether or not the perpetrator will actually obey it. And so it's not as safe of an option as simply granting the defense. And that's kind of where I think the tension is at this particular point in time. So I guess I'd like to think a little bit more, Reem, maybe you can help us think about whether or not the human rights bodies offer a potential solution, since there probably are human rights implications to this issue. How could we use those bodies to maybe get a result that is more efficacious for survivors?
Indeed, Nicole, I think we need to really consider the fact that this is a human rights emergency, and this is how I've described it also in my 2023 reports. Given that I raised the adjudication of the Hague Abduction Convention within this, against the broader backdrop of custody adjudications, child custody adjudications, but also therefore domestic violence. I want to just very briefly maybe mention some of these key human rights issues that are involved, because I think we need to change the chip, the way we look at this whole conversation. And therefore that will convey not only the emergency nature of it, but also help us in finding solutions. So we already spoke about Article 20 of the Convention, which is that article that allows courts to refuse the return of a child if the return would violate fundamental principles of the requested states relating to the protection of human rights and fundamental freedoms. And speaking of human rights, in fact, states are under obligation to prevent violence against women and children. So the right of women and children to live free from violence is an established human right. The issue, obviously, is that Article 20 is not invoked as much as it should be, really, on this issue. And states have an obligation also pursuant to public international law and consistent with Article 20 to exercise due diligence to punish past incidents of domestic violence and prevent future incidents of domestic violence, and to rehabilitate victims, including against the taking parent. Other fundamental principles of human rights law is, of course, the best interest of the child principle, which is articulated in Article 3 of the Convention on the Rights of the Child. This is not just a fundamental concept in international human rights law, but also national human rights legal frameworks. And it requires the well-being of children to be the prime consideration in all actions and decisions. And therefore, when we look at Article 13b, which provides this important exception to the general rule of returning a wrongful, removed, or retained child to their habitual residence, it states a court may refuse to order the return of the child if the person opposing the return can prove that there is a grave risk that his or her return would expose the child to physical or psychological harm or otherwise place the child in an intolerable situation. So in other words, if the return would be against the best interest of the child, but also if you think about the conditions in which a child might find themselves in, or even the mother, once the return has been effected. You have, of course, common law Article 3, which prohibits torture, inhumane and degrading treatment, and that is customary law. So if returning mother or child to their abusers can result in such grave consequences that they may amount to torture, inhumane or degrading treatment, you have here obviously a violation, a grave violation of international human rights law. And in refugee law, you also have, well, not just in refugee law, but another way of thinking about the prohibition of torture is the prohibition of refoulement, which is returning someone to a place where their life may be at grave risk, or where they may be subjected again to really inhumane, degrading treatment or torture. Then you also have the principles that mandate states to have child-sensitive procedures, take the views of the child always into consideration. So that's why children must be independently represented in procedures and must participate in such procedures according to their age, maturity, and understanding. And there must be child-sensitive processes. And also, if we think about mothers or the women affected, we know that also in international human rights law, any processes must be victim-centered. So victims must fully participate in the design of solutions, in redress. They are entitled to reparations. That's why, as Adrienne mentioned, it was so important. Actually, it was a right for victims and affected mothers to be present in the meeting in Brazil, and they have a right to be present in the meeting in October. This is not sort of a luxury thing. This is a right, because nothing about victims without victims. And the final point I want to come back to is, of course, the right of everyone to an effective access to justice and to effective legal procedures, and therefore also the issue of being able to rebut the presumption of no return of the child if that will be dangerous for the child. Now, coming to the specific question you asked me about the role of regional and international human rights mechanisms, yes, of course, as international and regional human rights mechanism, there is more that needs to be done, more work, more focusing on this issue, certainly. I think a lot has been already done with regards to the issue of domestic violence and how states and also courts must take into account prior history of domestic violence in all proceedings. Some regional human rights mechanisms like Grevio have done a fantastic job on this. I think Mesekvi also has also done some very good work on this. But I would say that we need to activate several strands of intervention at the same time. So not rely only on the UN or not expect only international and regional mechanisms and treaty bodies to do so. Although we need to continue to put pressure and bring emblematic cases to their attention that highlight the violence and the violations of human rights. But I think we can also and must continue to press our own governments at national level, either through parliamentary inquiries or through the child ombudspersons, National Human Rights Commission, women's commissioners, etc. So we need to really activate strands at all levels.
Thank you. Following up on your last point about what can and has been done at the national level, maybe Janina and Maria would like to talk about kind of things that are happening in your countries.
Well, in the United States, there have been some efforts to try to create guidelines for federal courts that have some DV perspective, or also to try to amend the implemented legislation. Like the last effort was in 2015. The hope was to get rid of that clear and convincing standard, include this exposure to DV as part of the grave risk. But sadly, although the bill was sponsored and lots of advocates worked on that bill for 2 years or more, it was never introduced. But fortunately, we have some good case precedents. The Supreme Court decided the case Golan versus Sada, where the Supreme Court vacated and remanded a decision from the Second Circuit that was affirming a decision from the district court ordering the return of the child to Italy with protective measures. And the Supreme Court basically said that this mandate for protective measures is this a textual categorical requirement is nowhere in the convention. And although it could be in line with the objectives of the convention, it's basically akin to rewriting the convention, because there's no such obligation that you have to categorically decide that you have to return a child at all costs. And we don't have to do that, because if we do that, then we will be placing that goal of return the child to the other country above all other goals. And the main goal of the convention is to protect the interests of children and their parents. So I think that the precedent by Golan versus Sada, it's a great precedent in the United States. And if I could just say something about protective measures, I know that anybody that is an attorney that works with domestic violence victims must have at least one story of clients who's had protective orders violated. We fail domestic violence victims every day. The judicial system fails them. So this idea that protective orders are or protective measures are the end of be all that will fix all the problems with the convention, it's kind of baffling if you look at it from a domestic violence perspective.
Well, so domestic violence and child abduction is a very hot topic in Brazil at the moment, actually. There are many things that are being done, but before I go into that, I would kind of like to also give you some context on why that is happening in Brazil right now. And that also actually has to do with some international human rights law. So Brazil has one of the most robust domestic violence legislations in the world, and it's called Maria da Penha law. And that law was only drafted as a result from a recommendation issued by the Inter-American Commission of Human Rights. And that because of that case and the horrors that happened to her, we created domestic violence legislation. And that domestic violence legislation also provides for a structure for victims. So that means that we have the police stations that are just for women. We have domestic violence courts that they can also attract the jurisdiction for custody, for matrimonial matters, as I said before. And it also created a sense of culture in the sense that domestic violence, it has a connection to family law, and it has a connection with child issues as well. Even so, that last year, the end of 2023, our civil code was altered to make it mandatory that if there is domestic violence involved in custody situations, custody must not be shared. It can only be sole custody. So those changes, they really created some sort of momentum also for this child abduction discussions to happen. And at the same time, many cases of Brazilian mothers who returned to Brazil started going to the press, and that moves things around. So what I'm trying to tell you right now is that we have the legislation, we have the structure for it, and there were also many cases being discussed, because with politics, it's also about momentum and timing. And in the end of 2022, a bill was introduced to the Congress to make it to basically include explicitly domestic violence as an arguable defense for child abduction. So that bill is currently being assessed by the Senate. It's still going through some sorts of modifications, and it's going to go back to the House of Representatives and may come into force, but that we have a long way ahead of us. And there are also, and that is, I think, the most interesting one, because having law is important, of course, because it's a clear-cut perimeter, but how that law should be interpreted is another issue. And that is being taken care of by 2 direct actions for the declaration of unconstitutionality at the Supreme Court. So those actions, they do not intend to make the Hague Convention unconstitutional, quite the opposite. It doesn't mean that Brazil is going to go out of the Hague Convention, but it means that these 2 actions, they ask the courts to consider the constitutional principles when applying the Hague Convention. And then we have a very good argument, because in our constitution, we have an article for the best interest of the child, but there is also another article, which is Article 226, paragraph 8, which provides for the state obligation to take all necessary measures to prevent domestic violence and to prevent violence in family relationships. So we do have a constitutional obligation to do so. And based upon that article, those actions were presented. So there are 2, as I mentioned. One is more broad, and one focuses on the issues of domestic violence. And there's one particularity about the second, which also asks the Supreme Court to say that even if violence is not proven, that it must still be considered. So suspicion, and that's not a very good translation, but basically indications of domestic violence. And I think that's where the heated discussion is on, because the question is, okay, if we are supposed to consider indications of domestic violence, how are we going to balance that with the duty to also not deviate too much from the uniform interpretation of the Hague Convention, and not to compromise the mutual trust that was reached once the convention was signed by Brazil. So that is very exciting. We might have a decision soon, because now we're really just waiting for the decision to be issued. The hearings have already happened. I was one of the lawyers that was representing a few civil society organizations, including Revibre, which is the one I coordinate, and Maria da Penha. And we hope that I have a feeling that we are going to lean in the direction of considering domestic violence, but at the same time, is how far is that decision going to go? But that could be one of the one of the first, I think, decisions at that level to basically establish a perimeter. And of course, that adds up with the fact that Brazil is hosting the forum in October. So we have to pay attention to that and how it's going to move forward.
So that is hopeful. Thank you for sharing that with us. So I want to turn to questions that we might have, but before I do that, I just want to end this discussion with what you all might do if you're kind of interested in this issue and want to do something maybe to further reform. First of all, I would be remiss if I didn't put in a plug for the Narcis Golan Initiative. If you're a lawyer, you heard about the inequality of arms. There's a great need for pro bono representation. And so please consider getting in touch with the initiative if that is one way that you would like to participate. Certainly, there are many groups working on this issue right now. You heard Revibra, Hague Mothers, Philia's Hague Mothers. There's the Women Against Violence Europe, Global ARC. All of those organizations, if you're interested, you could become more involved through those organizations. I think this is a political problem, not a legal problem. And so kind of just following up on what Reem said, I think thinking nationally about what people can do to make a difference will be important. And so certainly we saw the great effect of political activism in terms of getting that first forum in South Africa. There were 38,000 people who signed the petition, and people who wrote stories, about their experiences to the Permanent Bureau, and that made a difference. So all of that is really important. I see Reem's hand up. Reem?
Yeah,
Adrian, too.
I wanted to also say that we need to think about the non-legal aspects of this. Over the years, I've seen many cases where mothers and children were happy to share their experience. Mothers wanted to come and did come to testify in parliamentary inquiries, but then were subjected to abuse and further threats, and of course were at risk of having even further reprisals against them, being, have their kids removed or other things of the sort. So it's how to educate the public, how to gather data while at the same time protecting the confidentiality of those involved, of the victims, and also not exposing them more to danger.
Thank you. Adrian?
Yes, thank you. I wanted to say a bit about another mother whose situation is dire at the moment. It may be that people who are attending can help with representations. And that is the case of Jewel Lazaro, who I think many of you will have heard of. Jewel is a US citizen, mother of 2 children, and she has been sentenced to 3 years and 3 months in a Spanish prison, and which we understand is due to happen imminently, literally within days, possibly 3 days, unless we can stop this. So Jewel had taken her eldest daughter back to the US to escape domestic violence in Spain, and the father then brought Hague Convention proceedings in the US in 2021, and he explicitly agreed in those proceedings that he wouldn't bring criminal proceedings against her or separate her from the children if she returned to Spain. And immediately on her return to Spain under the Hague Convention, the father pursued criminal charges against her, resulting in this conviction. And there have been travesties of injustice in her proceedings. She wasn't granted a right to appeal to the Spanish Supreme Court or have her case re-examined, despite the severity of the circumstances. She's going to be forcibly separated, not only from her eldest daughter, but from her 8-month-old baby, who she's still breastfeeding, and she's the sole caregiver of. She's had no access to legal aid, which has severely restricted her ability to represent herself. So Jewel's situation is absolutely dire. And can I just say one last thing about how this issue of comity under the convention and how it applies to cases like that. We're not only looking at international law, we've got to look at our own domestic law. In the US, we've got Caden's law, which is being rolled out. We've got the Maria de Pena law in Brazil, positive changes in Australia. And in the UK, we've got the Domestic Abuse Act, which has a statutory definition of domestic abuse, which explains it as a pattern of behavior, including coercive control, and importantly, recognizes children as victims of domestic abuse in their own right if they live with domestic abuse. And yet we have such a different approach to it in Hague Convention proceedings. So to achieve comity between nations, let's let the convention catch up with the positive developing approach within domestic custody proceedings in an increasing number of contracting states, rather than trying to achieve comity by narrowing it down to this terribly outdated and restrictive approach to domestic abuse. But if anyone wants to help Jewel's case, please contact Hague Mothers.
Thank you, Adrian. Do we have any questions that we don't have much time, but we should try to get to a couple at least.
Yeah, we have some online, and if anybody's in the room that wants to pass me questions, just let me know. There were 2 online that both kind of had to do with education around the understanding that domestic violence causes harm to the children. So I'm just going to read one of them. So what does the panel think is the best way to shift courts legal frameworks and societal ideas around domestic abuse so that more people and adjudicators understand that a child growing up in a home in which there is domestic abuse is being greatly psychologically harmed.
I would like to say something. I think that the use of experts on the effects of domestic violence in children in hate cases is so important. I think that, as we said, federal judges sometimes are not educated on domestic violence, and unless they hear from a expert that did a psychological evaluation of the child, they might not understand the effects of adult domestic violence in a child that was around and the risk for that child to become a victim in the future. So I think that's very, very important.
I also like to second that, because I can't remember now the author, but I read a very interesting study the other day that said that during Hague proceedings, evidence is kind of prejudiced, because more often than not, when there are allegations of domestic violence, there will be an expert inspection that they will call psychologists and social workers to talk to the children. But the thing is, even if it's just a few weeks, once the child is out of the abuse and the abusive home, the child will have developed. And then the evidence that when they talk to the child, they won't see the child that damaged, and not in that sense, because the evidence is mostly when you're talking to the child at that point, they will be away from the abuser. So having expert witnesses really helps with that, even to make that point. So yeah, I would just like to second that.
Can I add one thing too? I mean, I'm a proponent of a new convention that deals with safety for people who are fleeing or traveling internationally. And one of the things that I think should exist in that new convention is a presumption that children are harmed when there has been domestic violence, so that you don't have to put on expert evidence. We've kind of done that in the domestic custody area, right, with kind of presumptions that it's not in the best interest of the child to be awarded to a domestic violence perpetrator. And I think we need something at the international level so that people don't have to do that, because it is a problem.
We are at time, but I'm going to just do one more question from the room in all fairness. So is there recognition of Article 20 that you know of as a legitimate defense under 13B? This question is in US courts, but I'd open it up to, is anyone aware of, in any courts, Article 20 being used as a successful defense?
There are very few Article 20 cases. There was one actually out of Puerto Rico that dealt with domestic violence, and the courts used the language of Article 20, but we're talking about Article 13B. And that's the only one I've seen in the domestic violence context. So it's unfortunate that I think there is, for whatever reason, hostility. I don't know if you've seen other Article 20 cases.
Actually, it's getting that line of defense is getting more popular in Brazil, especially because that argument has been raised in one of the Supreme Court actions, and even by the Attorney General's office, that Article 20 is underused, but not in the not in international law perspective per se, but more in the domestic, considering it's the fundamental rights, and they were looking into more like a public policy, and that's actually very interesting. It's kind of legalese, but even when we read the explanatory report from the Hague Convention, when it comes to Article 20, they say that it's a public policy clause, and it's read in another way. So basically, when I see in Brazil happening is in the sense that they would be breaching the domestic violence, the domestic violence legislation, and also the values and principles of the Brazil public order, the legal system. So that's where it goes, but it's getting more popular for sure.
Okay, thank you. I'm really sorry that we're not able to get to all the questions, but we are at time, and I think most of the panelists are going to stay for lunch, so maybe people in the room can feel free to talk to the panelists about their questions. I want to thank our panelists so much. I thought this was an amazing panel. I learned a lot. I've heard from you all before, but every time I listen to you, I learn more. So thank you for joining us. This means a lot. And thank you for everyone in the room for joining us. And with that, we're going to end the panel. We'll log off the Zoom in a second, and please help yourself to lunches, which are right outside. Thank you.
Thank you.